Counsel's indicated he has paper discovery. Do you have digital available for him?
Yes, Your Honor, it does look like it's available. I just have to be transparent. Evidence on Commons not working on my laptop right now, but I will have one of the interns send it out.
All right, so she's going to send it to you. You're going to get it to him today?
Yes.
All
All
right.
right. His client's in custody. What's that?
I just said sounds good with respect to discovery. I'll be on the lookout for that.
All right, and then I have his exam next week at 1 o'clock.
What date is that, Your Honor?
October 15th.
October 15th, 1 o'clock. That actually works. Yes.
Perfect.
And I'd like to address bond, Your Honor.
He doesn't have anywhere to go. His mom came in and said he couldn't go there.
So I understand that his mother does not want him to stay with her. However, she did confirm that the townhouse he was living at is available. He was renting a townhouse, and mother confirmed that the fiance that was involved with this incident is no longer living there with her children. So it appears to be empty. That is the address on Waddell Street, 16118 Waddell Street. My client did have a pretty well-paying job. I spoke to his boss with All Innovative Services. He does construction, renovation, and his boss tells me that he would still employ Mr. Pollington, that he does fantastic work. So he's trying to hang on to both a place to stay as well as his livelihood, his means to make some income. So he's really just desperate trying to get out of jail. He understands absolutely no contact with the complaining witness in this case. And his bond is right now $2,500 at 10%, and he doesn't have the ability to post that $250. So I'd ask Your Honor to consider a personal bond with the tether to the Waddell address.
Yeah.
I would, the people would oppose any modification to the bond at this time. The charges are very severe, one of them involving arson. I was in contact with the complaining witness. I know that they were very scared. This involves, the use of gasoline on the property.
I thought it was, he put baking grease on his foot.
No, he did light the grass and apparently his foot on fire. I don't want to misstate the facts exactly, but that's what I remember.
I skimmed the discovery because I just received it, but I thought it was bacon grease as well. And I should point out my clients denied these allegations.
It would be my mistake if it was that.
I mean, there is an allegation. I mean, the investigator's report says it was bacon grease and it was his foot. I mean, obviously these are just allegations. I also have to look at likelihood of conviction. There's allegations in here that, the complainant indicated that she'd been punched multiple times in the face and then recanted that story and said she was just pushed. So, I mean, that goes directly to your likelihood of conviction if you have a complaining witness who's got some credibility issues and got a guy who put bacon grease on his foot and lit his foot on fire. Is that what is really happening here today? Is that really the allegation in front of me?
Your Honor, when I spoke, would you like me to go over what I had heard?
Go ahead. I mean, I wanted you to go over the allegations. I don't want you to, but yeah.
From what I was told, it was that it was bacon grease. That was spread on the lawn and that it was lit fire and then he stepped into it. So that's what I had heard. From what I recall, the complaining witness was cooperative. The report may say otherwise, but from what I recall, that was sorry, Judge.
We've got a problem. Sorry.
What was it?
I don't know. We've had giant spiders in here the last couple of days. All right. Sorry. We had a minor spider emergency in the courtroom. Okay. Look.
Again, that's what I have written here, but I don't want to mistake the facts and mistake the court.
I don't see got another felony pending.
I'm not aware of any. I mean, I'm trying to look at the allegations now, Your Honor. I'm not seeing the lawn aspect of this. I see that he went on the lawn at one point, but the breaking grease apparently happened inside, allegedly.
I was just present for the swearing on this, and I know it said right in the report that there were allegations made, then they were recanted, then
I'm gonna see if there's anything pending as well. I didn't see anything. I don't have anything in my system that shows any other pending felonies.
is Ms. Kellogg, are you out of that house?
I'm currently moving into a different apartment.
Okay, so you're not staying at that location anymore?
No, I'm still trying to get more of my stuff out today and tomorrow, and then I'll be in my new apartment.
Okay. All right, here's the thing. I'm going to Mr. Eichinger, bring it up next week when I hear testimony. I'll see everyone next week. I want to hear testimony. He's got a 2,500, 10% with the GPS bond. He's got a low cash or low 10% bond as it is. After I hear testimony, I'll entertain a bond argument.
Thank you.
All right, we're all set. No, Mr. Pongton, you talk to your attorney. You're all set.
Can we have a breakout room for a few more minutes? Thank you.
Can you talk to him afterwards? Because I have to give Ms. Richards' client in there as well.
Oh, sure.
So I can put him in. I can ask them to bring him back in, or you can contact the jail, but I got to get these moving at the jail.
Understood.
First, my officer for the resisting and obstructing charge is not here, so I cannot proceed at this time with that charge. And I also wanted to let the court know that I may be adding charges at your testimony.
For what?
For the use of the liquid, the lighter fluid. There is a charge that I believe there may be probable cause for, and I can go over
You charge him with prep to burn already. I mean, I'll hear the evidence, but I will tell you what I'm not a big fan of, and I don't mean this directed at you, I just mean this in general. The prosecutor's office has submitted an investigator's report. There is a prosecutor that sits down there in their little tiny closet office and reviews it for charges that they believe are appropriate based on the evidence that's in the investigator's report. And those charges are issued. And some, you know, if the evidence is there and it's appropriate, but I'm not inclined to just add charges on everyone that holds their exam. I mean, I'm not inclined to do it because sometimes it feels to me like it's a punitive, like, oh, if you waive your exam, you get to go downtown on the charges there, but if you hold, I'm going to add X, Y, and Z. And I'm not saying you're doing that. I'm just saying in general, you know, I find it problematic when case after case after case, I see added charges that are, you know, I don't want to say petty, but at some point it's like, what's the evidence show? What is supported? And like, let's go. But I'll hear the evidence, and if it's there, I'll hear your argument on it, Ms. Louie, but I'm not a huge fan of it because sometimes I think that it's misused. So, okay, anything else?
nothing, just unusual sequestration.
Any objection?
No objection. We join in that request.
All right, granted. If you're a witness on this case, please step in the hallway. Otherwise, you guys can have a seat and call your first witness.
Your Honor, the people call me Betty Kellogg.
Look, if you can come on up to the witness stand here. Ma'am, can you stand and face me and raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, if you can have a seat in that chair. Ma'am, tell me your first and last name.
Betty Kellogg,
Can you spell Kellogg?
Kellogg.
All right, great. Your witness.
Thank you. Ms. Kellogg, I'm going to take you back to September 20th, 2025. Do you recall that day?
Yes,
Did you make contact with somebody named Brandon Tollington on that day?
yes.
Who is that to you?
I was with him for 2 years. He was my boyfriend.
And were you still together at that time?
Yes,
Do you see him in the courtroom today?
yes, I do.
Could you point to him and tell me the color of his shirt?
It's green.
And let the record reflect the witness has identified the defendant.
Record shall so reflect.
Tell me what happened that day with him.
We started off a normal day. He went to work. He got off of work and stopped at the liquor store. And the battery wouldn't start on the van. And his mom came in.
Who's him first?
Brandon.
Okay.
Brandon called his mom because he couldn't get the car to start. So she came and started it.
So let me stop you there. What do you mean she came and started it? Did she go to where you were? Is this the house?
She went to the liquor store to jump the van.
Were you there?
No,
Okay, so tell me, when did you make contact with him?
when he got back with his mom
And so he got back where?
to our townhouse
Okay, and where do you live?
at 16118 Woodell Street.
Where you
Say
live?
that one more time. 1-6.
118 Woodell Street, Taylor, Michigan.
Okay.
And that's WEDDELL.
Yeah.
And is that in the county of Wayne? City of Taylor, County of Wayne.
Yep.
And so what happened when he got to your house?
We were having a normal day, just hanging out with each other with Cassius and Daisy, which are our children that were there at the time.
So let me stop you there. Who's Cassius?
His son,
How old is he?
he's 5.
Okay, and then you said Daisy. Who's Daisy?
Our daughter, she's 1.
And what happened next?
He decided we were gonna make bacon and eggs for dinner, and he cooked the bacon up. He came outside to tell me, are you gonna come in and make the eggs? Because I always make the over medium eggs. And then he went back inside the house, and then he came back outside and he's like, there's not enough eggs. And I was like, I can go get more eggs. He's like, no, I'm not gonna go get more eggs.
Let me just stop you there. At this time, were you outside?
Yes,
What were you doing outside?
smoking a cigarette.
Is this on a porch or?
It's just like, we have like a little walkway up to our townhouse. So we were just sitting in chairs, just, like I was sitting in a chair and Cassius was sitting in a chair. We were just sitting there.
And then was Daisy there as well?
Daisy was in the house in her pack and play.
And then, so after he had told you about there wasn't enough eggs, what happened next?
He went back in the house. He made up scrambled eggs. And then he came outside to say that they were done. And when I went into the house, he had dropped the pan of eggs all over the ground.
So let me stop you there. Was this an accident or was this on purpose?
It was an accident.
Wait. Did you see him drop the pan?
Yes, I seen him drop the egg.
All right. Ask her again.
I'll ask this. Was it an accident?
Yes.
And then did he just drop the pan?
Yeah,
with the
he
accident?
accidentally dropped the pan, and then he picked up the pan and he whipped it at me, and it hit me in the foot.
And so what do you mean by whipped it?
He threw it, sorry.
And let the record reflect the witness used her right hand and kind of snapped it forward.
Yeah,
Record shall so reflect.
And where did you say it hit you?
in my foot.
About how far were you when you did this?
Probably a little bit closer than what you are to me.
And did he say anything when you did that?
I don't remember.
Do you remember if you remember, what the pan looked like?
It was a big frying pan.
Do you have an estimate size? If you know.
No, I don't know how you do sizes, like 15-inch pan. I don't know, it's about this big.
Let me face me and show me
It
that.
was like about this big.
What, maybe a 12-inch it looks
Yeah.
like?
That looks about accurate.
Oh, we can all agree it's a large pan.
Yeah.
Oh, is this a frying pan?
Yes.
Okay.
It's like one of the deep ones. Like the deep.
Okay, and then Which foot did it hit?
My left foot.
And what happened next?
We went outside. We went outside and we were sitting there. I was sitting down in the chair and his son was sitting like next to the door, and he squirted lighter fluid by my feet in front of me and lit it on fire. And then
I'm gonna stop you there. Were you outside sitting on the chair?
yes,
And you said there's lighter fluid. Where did this lighter fluid come from?
it was sitting up on the window outside our townhouse.
Did you observe him grab it?
Yes, I watched him grab it and then squirt it in front of my feet, and then he lit it on fire, and then he squirted it on his legs and on his boots, and then walked into the fire that was already still there. And then
Let me stop you there. Do you recall what the lighter fluid packaging looked like?
it was a white big bottle with a red top.
And he squirted it. It had that kind of nozzle. Like
Yeah.
nozzle. And so I just want to clarify. He did it on the grass?
Yeah, he did it on the grass first.
And where else did he?
He then squirted it on his legs and boots and stepped into the fire. And then after he did that, he ran into my home.
So just to clarify, did he light the ground on fire before stepping in it?
Yes.
And where exactly was this place where he lit?
Right in front of my townhome.
Was it in front of you?
Yes.
Did the lighter fluid get on you at all?
I mean, it was at my feet, so it kind of, it could have ignited me if the fire, I don't know. No.
Just for the record, you don't know if it was on you?
No.
And was this grass that he lit?
Yes.
And did you take a picture of that?
Yes, I did.
So if I were to show you a picture of the area that he lit, would you recognize it?
Yes.
And of course, right when
Have you seen this photograph?
yes, Your Honor, it was shared.
Yes, I have, Your Honor. No objection.
All right,
And I'm so sorry.
it's admitted.
Evidence.com just, of course it refreshed on me. One second. And I have the Zoom open. I'm going to share the screen and I'll show defense exactly which one I'm talking about in just a second. I don't know if that's the same one. I prefer to just use that. Oh, here it is. So I'm going to go ahead and share screen. So, did you say it was admitted, Judge? I just want to.
It's admitted.
So
People's Exhibit
If I may
1.
approach the witness so that she can.
You may, well, there was no objection, so but you can authenticate it if you want. It's admitted.
Thank you. I would like to approach her so she can remember which photo.
Yes. And then there's the chair right there where I was sitting, and it was actually up a little bit closer than that.
And so is that the photo that you took?
Yes.
Does it appear to be manipulated or altered in any way?
No.
And is that the one that you sent to the police department or the detective?
Yes.
And is that exactly where he had squirted the lighter fluid before he lit it on fire?
Yes.
And after he had stepped in it, did he say anything?
He was like, I'm on fire. I can't believe I'm on fire. You lit me on fire.
I'm just trying to stop the sharing now. I don't know how to stop it. Oh, here.
Press that red button.
I got it. And what happened next?
Then he ran into the house. I had looked at my stepson Cassius, and I said, "Are you okay?" And I went into the house, and he was ripping his boots off that were so it was like almost put. It was basically put out. You could like see like the steam from the boots, and he was ripping off his boots off. And when he got the boots off, he was looking at me like, "You did this to me," and I was like, "I didn't do anything to you."
And what happened next?
And then he started freaking out on me, and
Can you describe freaking out?
started like screaming at me and like throwing things around.
What happened next?
And then there was a I don't know how to explain it. I took Cassius upstairs to go to bed. And after I took Cassius upstairs to go to bed, I came back downstairs and he started yelling at me, which I can't remember what he was yelling at me, but then he started punching me in my face multiple times.
So let me stop you there. This was after you had gone upstairs with I think it was your stepson?
Yeah.
And then you came back down?
Yeah.
When you say punch, was it like open hand or closed hand?
It was like a 2 or 3 piece. Like hitting, like, like when you hit somebody, like.
Describe 2 or 3 pieces.
Like he punched me twice with his right hand and once with his left, like it was like boom, boom. Like it was so quick how many times he punched me in my face.
And by saying 2 or 3 pieces, is that about the amount of times he punched you?
Yes.
And what happened next?
Then he started just throwing me around the kitchen and hurting me. Like it's so small in there. He was just hitting me over and over again. And then I escaped, like got to the front door and I was like hesitating to get out the front door and he was hitting me from behind. And then when I got out the front door,
What happened when you got out the front door?
He shoved me on the ground and I caught myself as he shoved me on the ground. And then I went over and started banging on my neighbor T's house, telling her to let me in, that he was trying to kill me. That he was
Who was your neighbor?
T.
Could you say their full name?
Tiara. I don't really know her real name. I just know I called her T.
And what happened next?
I went into her place. She helped me call 911 and I was waiting for the cops to get there. And then Brandon started screaming at her door and like banging on her door saying like, come outside. And she's like, you need to get out. You're going to have to leave.
So let me stop you there. So while he was screaming, did anything else happen?
I was in T's house waiting for the cops to get there.
And did the cops arrive at any time?
No, his mom, I called his mom and his mom was there. His mom got there. And when I went outside, I ended up going into her car and we left because he was being crazy. Like.
And prior to you leaving, was he still outside?
Yes.
Did he do or say anything to you before you went into his mother's car?
I don't know. Like I just was so focused on getting into her car so he couldn't hurt me anymore.
And what happened after you left?
We went to her house. I went pee. I looked at myself in my face. I kind of like splashed my face with water. And then I got a hold of the cops and the cops said to meet them back there.
And so did you end up going back there?
Yes, I did.
And did you speak to any officers?
Yes, I did. I talked to Officer Scott.
And did you write any statements that day?
No.
What were your injuries from that?
I had multiple bruising all over my body. They did do x-rays of my foot, but it wasn't broken. It was just severely bruised, really, really bad.
So did you
Objection as to hearsay as to what they said her injuries were.
Wait, what she said she had x-rays, it wasn't broken, it was just bruised really, really bad.
Okay.
Right?
Thank you.
Did you say they said it was bruised really bad?
The doctor and the nurses.
No.
I mean, did you look at it with your own eyes?
Yes.
Was it bruised?
Yes.
Okay.
And you said you had bruises all over your body? Could you?
I had bruises like on my arm from him grabbing me. I had bruises on my back from him hitting me in my hitting me from behind when I was trying to get out the door.
And you indicated that there was an x-ray. Did you go to the hospital after this incident?
I went the next morning.
And just to clarify, what exactly happened with your foot from what you know?
what happened to my foot. It's just really, it was really bruised and
Was it broken?
no,
And it was that bruise from on your foot, was the injury on your foot from what happened with the pan?
yes,
And were there any other injuries that we didn't speak about?
no.
I have no further questions, Your Honor.
Cross.
Good afternoon, ma'am. Backtrack a little bit. So you had been in a relationship as of September 20th of this year with my client, correct?
You say that?
So this incident occurs on September 20th of this year, correct?
Yes,
You had been in a relationship with him for about 2 years
yes,
prior to this.
yes,
So you mentioned my client stopping at the store to pick up some alcohol, correct?
no,
You didn't say that on direct examination?
She said he stopped at the liquor store on his way home, but she wasn't there to see that happen.
Understood. So he never brought any liquor home that night? He did. You would agree that you were drinking that night, correct?
yes, we did,
You were drinking tequila.
yes,
You both drank a significant amount of tequila.
no, I didn't,
You did not.
no.
You did not drink.
We did drink, but we didn't drink a lot.
So you were drinking tequila starting in the early evening, about 5 to 6 p.m.?
Yeah,
And that continued to the time of this incident.
yes.
This incident started around what time that evening? The argument with the eggs and the bacon.
I don't know.
Was it about 8 o'clock? It's approximate time.
I don't know. I wasn't paying attention to the time.
Understood. So you were drinking this tequila from 5 or 6 up until that point, whenever the argument starts. Correct?
Yeah.
Now, with respect to this argument, it starts with my client cooking some dinner.
Yes,
He's inside cooking some dinner and he asks you to come inside and cook the eggs.
yes.
Do you ever cook the eggs or does he keep cooking the eggs?
He usually cooks the scrambled eggs. I always cook the over medium eggs because he's not good at it.
What was the last thing you said?
I always cook the over medium eggs, but he made scrambled eggs.
He made scrambled eggs. So he's cooking the eggs, but he's also cooking bacon, correct?
He cooked the bacon first and then cooked the eggs in the bacon. Grease, like the bacon grease, but like the leftover, like stuff that's on the pan.
Now I understand. He's cooking the eggs in the bacon grease. At some point, you come inside, correct?
Yes,
He dropped some bacon grease on his right calf.
no,
No, never dropped bacon grease.
nope,
You never told the police that he dropped bacon grease?
nope,
So you don't know if he was burned by bacon grease on that night?
he never burned himself with bacon grease.
Never burned himself?
No,
You took a picture of his boots from that night,
Yes.
correct? You turned those over to the prosecutor?
the pictures of the boots.
Of the boots? Correct. You took
I
pictures?
took a picture of the boots, yeah,
Of the
and I
boots.
sent it over.
Referring opposing counsel to what I'll call defense exhibit A.
Hey,
And I have no objection.
May I approach her?
you may. And are you moving for its admission over with no objection?
If there's no objection.
I have no,
It's admitted.
Ma'am, I'm handing you or showing you defendant's exhibit A. Is this the picture of the boots you took?
Yes,
When did you take this picture?
the day after, day after, I think.
So these are the boots you're saying my client was wearing on the night of the incident.
Yes,
These are the boots he was wearing when he stepped in the fire outside.
yes,
These are the boots he was wearing when he dropped, you're saying eggs, correct?
yes.
But you're saying he dropped eggs, but there was also bacon grease in the pan.
There was no, it was just like he dumped the bacon grease into like a little like white pot. And then he cooked the eggs in the pan.
So you're saying, well, you would agree if I show you this picture again, that the left side of the right boot appears to be melted or something's wrong with it,
Because
correct?
he lit it on fire.
Because he lit it on fire.
Yes.
That was not from the bacon grease?
No.
Since this is already admitted.
And then, Your Honor, defendant's exhibit A. So my client is wearing those boots. He drops the eggs. Then your testimony is he picks up the pan again and throws it at you?
Yes.
He throws it at you because, what was your explanation?
Over the eggs.
Over the eggs that he dropped.
Yeah. Yeah. Over there not being enough eggs.
How many eggs? How many eggs did he throw?
He made 6, there were 6 eggs.
How many people are eating eggs?
Me, him, or me, Brandon, Cassius, and Daisy.
Daisy, your 1-year-old,
Yes.
eating scrambled eggs?
Yeah.
Okay. So he throws it at your feet. This is a pan.
Yes.
The pan hits which foot?
My left foot.
What are you wearing on your feet?
I had no shoes on.
It hits you on your left foot, and then your what's your testimony after that? What happened after that?
We went outside and to sit out. We went outside. Well, and he lit the ground on fire in front of me.
He lit the ground on fire in front of you. Now, we already saw that picture. That picture shows some grass in a dirt area.
Yeah.
This is the area you're showing the cord where he lit it on fire.
Yes.
You have a baby pool at your house, correct?
Yes.
This is not the area that's just worn because the pool sits there?
No. The pool wasn't even on that side. The pool was on the other side.
Well, I understand it could be somewhere else at the time, but that's not normally where you put the pool.
No.
So he lights the ground on fire. You're standing close by, correct?
Yes, I was sitting right there. He squirted it right in front of my feet.
Right in front of your feet.
Yep.
He lights the ground on fire. What does he use to light the ground on fire?
A lighter.
Light. Where did he get the light?
He had it in his pocket.
So he lights the ground on fire, then he steps in the fire, correct?
No, then he pours the lighter fluid on his legs and boots and then steps into the fire.
So he lights on fire.
He lights himself on fire, yes.
Now you were around this whole night of this incident, correct?
Yes.
To your knowledge, my client was still present after this incident, after he lights himself on fire, correct?
Yes.
So eventually the fire goes out.
Yeah.
And he's able to then chase you to your neighbor's house later, correct?
Yes.
He's talking to the police later. You saw him talk to the police.
No, I didn't see him talk to the police the first time because I left with his mom because I was in danger.
But the point is, you saw him later, right?
I saw him on.
You saw him later that night.
Yes.
He didn't have any shoes on, correct?
I didn't have shoes on, he did. He had his boots on.
He had his boots on later that night when you saw him.
No, he took them off after he lit them on fire.
And I want to be clear, those boots that you're saying lit on fire are the same boots shown in that picture
Yes.
that we admitted as evidence.
Yes.
He runs in the house on fire.
Yes.
That's a very significant fact, correct? You talked to the police at around 10 p.m. that night. Is that a yes?
I don't know.
You don't know.
I don't know exactly the time frame at all.
It was that night. It was about 10.
Yeah.
Is that safe to say? And you're aware that the police wear body cameras, right?
Yes.
It records conversations with witnesses.
Yes.
Okay. You spoke to a female officer, Officer Scott.
Yes.
You know she's wearing a body camera.
Yes.
You gave her about 7 minutes worth of an accounting of what happened, correct? Is that right? Right.
Yeah.
During that conversation, the officer asked you what exactly happened that night.
Mm-hmm.
You told her what happened that night. Would you agree?
I tried to.
You tried to. I mean, she didn't. She gave you the time to speak. Is that safe to say? She gave you the opportunity for you to tell her what happened that night?
Well, yeah, she did give me time to speak, but And everything was so, like, everything happened so fast that I was just trying to get out what I could tell, like, you know, I could tell her.
Everything happened so fast. Like what, the stuff that
It
happened about
was
an hour
traumatic
ago?
for me.
I understand that, but you're there with my client's mother, correct?
Mhm.
You're there with the police officer.
Yeah,
My client was not around at that point.
yeah, he was standing right there talking to the cops. After I talked to the cops by the townhouse building, then I needed to get my purse, my shoes, and like my belongings were in the house. And I had to walk over there and I got them from Brandon. I got my things from him. But while we were standing right there, like they made me leave after that.
You mentioned some things just now, today, on direct examination. I'd like to go over that and compare it to what you told the police. All right. So when you talked to the police, you mentioned my client spilling some bacon grease.
No, I didn't.
Correct? You never said that.
No.
You mentioned my client squirting some lighter fluid, right? You didn't say anything about him running into the house on fire, correct?
I talked to the detective. I told him.
When you talked to the detective, what, 2 days later?
The next day or 2 days later, yeah.
You would agree, you never told that first responding officer that my client lit himself on fire and ran to the house.
No, I didn't.
You mentioned that my client punched you a number of times.
Yes.
You did initially tell the first responding officer that he punched you a few times,
Yes.
right? And the first responding officer looked at your face.
Mm-hmm.
The first responding,
Is that a yes? Ma'am? Is that a yes?
Yes.
that first responding officer indicated she didn't see any injuries to your face.
Yeah, she did say that to me.
After she said that, you then modified your story.
No, I didn't.
You did it. After she said that, you said my client actually shoved
He did
you.
both.
He shoved you. You said it felt like a punch, but it was a shove.
No,
You never said that?
no.
You also mentioned a number of other things, my client hitting you in the back, correct?
Yes.
You never mentioned that to the officer you first spoke with that night.
I told him that he tagged me from every direction.
You did?
Yes, I did.
You mentioned that did my client chase you to your neighbors? Is that
Yes.
what you mentioned? All right, you never mentioned that to the first responding officer.
I told him I ran over to T's house.
You'd be able to recognize yourself on body camera from that night.
Yeah.
Or if I may share.
You may.
Let's see. I'm going to just show you a brief clip and ask you if you can identify yourself in this video. Am I able to share sound?
You're gonna have to mute your device so it can play through the Polycom, and then it should work. Try to
All right.
press play now after you. No? Oh, every day's an adventure. So, I mean, you might just have to, if you try and share the audio while you're playing the video like this, it's going to have that feedback. So I don't know if you want to approach and just disconnect from the Zoom and play it, and then Miss Louie and I can come up and watch with the complainant.
Okay.
I'm okay with that.
So let me just make sure.
If not, it'll just have that feedback.
All right. For future reference, do you have an HDMI connection?
We have that court up there, and yeah, and maybe that's how the prosecutor's able to share the volume through the Polycom system, I'm not sure.
I just try that.
You're gonna have to take your laptop.
You might have to put your laptop closer.
Okay. That'd be fine. I'm gonna accept it, Your Honor.
Just off the record real quick, MDOC, is this MDOC present?
Yes.
Do you have a time you have to have him back by? Okay, we're going to hold it, he's here.
That works.
Let's see if this works.
More, and then he threw the whole pan like at the floor and then threw it at me. If you look at my foot.
Okay. For the record, I'm showing you a video. It's labeled with 2025-09-20 at the top right corner. It says 22:05:12. That appears to be 10:05 at night. And there's an individual in this video. Ma'am, is that you?
Yes,
And does that look to be you from this night in question?
yes,
The night in question being September 20th.
yes.
Does anything appear to be altered about your image or how you sound on that night?
No,
So you'd agree it's a true and accurate view and accounting of how you looked and what you said? Move to admit defendant's exhibit B, Your Honor.
Admitted. Any objection, Ms. Lewis? All right, admitted.
I stopped it around 125. I'm just going to back it up so we can have the full statement. So, ma'am, I'm just going to play this, then I'm going to ask you some questions about this.
okay.
Oh, what's going on? So, a couple hours ago, we got in a fight because we didn't have enough eggs to feed the kids, and I told him I had to go get some more, and then he threw the whole pan at the floor, and then threw it at me. If you look at my foot is black and blue from him hitting me. And then I ran to my neighbor, and my neighbor T held me for a little bit, and she's like, "Well, I don't want my kids involved, but I want me involved." So she kicked me out of the house, and then she showed up and took me to her house, and my baby's there, my 1-year-old baby's there, and I'm terrified for her because I want him to hurt her.
Yeah, he's not gonna hurt her. I'm his mother.
And I'm just, I'm terrified about it.
Okay, do you have any other marks in your body that's the thing that happened? You threw the pan and it hit your foot?
I don't know. He punched me in my face a couple of times.
When?
An hour ago.
You didn't mention that. So what happened, the physical part? That's the most important part.
After he threw the pan at me, I went to T's house, and then I left. And I came back home, and he was like, "No one's gonna believe you." And he hit me a couple of times in my face. And
Do you have any marks on your face?
I don't know. My nose has been bleeding. If I blow my nose.
How did he hit you, with a closed fist or an open?
Just hit me. I don't know how to. Everything happened so fast.
And then my son's got 3rd-degree burns on his ankle too because a pan.
He punched you. I'm sorry. Just give me a second. He punched you in the face multiple times with a closed fist?
Yes.
You don't have any mark on your face?
So he hit me in my face, and he let himself on.
Where did he hit you in your face?
He hit me.
I understand that. Where?
I don't know how to explain it. He's hit me.
How many times did he put in the past or today?
Today, once or twice. He's hit me. And he lit himself on fire with lighter fluid. In the front yard, if you look at our front yard, he lit himself on fire with lighter.
Was he throwing the pan at you or at the floor?
No, he threw it at me at the floor, but he threw it at me.
So he punched you.
How did he get the 3rd-degree burns on his ankle? I don't understand. Can we go to the place? It's right over here.
He was lighting.
I already talked to him. It looked like he was just waking up. How long ago did this happen?
This happened recently.
All right. Do you want to press charges?
I mean, I just know that he lit himself on fire with lighter fluid.
What are you talking? He did this today?
Yes. Of course I am. I still love him, even though he hurt himself.
What are you asking him to do?
I just want my daughter. I just want my daughter. I don't want her to hurt. Yeah, that's like, honestly, that's what I'm trying to do. I just want my daughter. Because I don't want him to hurt her after he hurt me.
He was waking up from sleep when I
No,
talked
he
to him.
didn't. He did not wake up from sleep. That's not what happened.
He's bipolar. He has issues.
Was he throwing the pan at you or at the floor? It seems like he was throwing it at the floor. No, I don't know how he hit you, but you don't have a mark on your face if he punched you multiple times in the face.
He did hit.
Okay.
Like, I don't know if he punched me, like, you know, like he shoved me. And
So now he shoved you. Did he shove you with? Did he just shove you, or did he punch you in the face?
It
with
felt
the
like he
closed fist?
punched me. Like I don't know how to like explain it.
It felt like he punched you.
Yeah.
But you don't know if he punched you.
No, because he told me to get out of the house. Like it.
Okay.
Let me ask you this. Go up there, check on his well-being because of his
This
work.
is my house.
Find a solution.
I'm sorry.
Okay. Sounds like you guys had a disagreement.
You guys-
Okay, just stopping the exhibit at 5:14 on the timer on the bottom left. Okay, so you heard some of that conversation, some of that back. And just to clarify, it's already into evidence. We don't have to go through everything, but you did not mention my client running back into the house on fire, correct?
No.
You did not mention my client hitting you in the back, correct?
No.
A couple times you said he threw the pan at the floor, but you also said he threw it at me.
Yes.
You said it felt like he punched you.
It was just all happening so, like, it was happening so fast. He was hitting me so, like, he was punching me and hitting me so much that night that I can't, like, he did punch me though. Like, he was punching me and hitting me.
You said nothing about my client choking you. You'd agree?
Yeah.
You said nothing about my client body slamming you, correct?
No.
You said nothing about my client pushing you to the ground.
No.
You never mentioned falling to the ground. Is that a yes? That
Yes.
you never mentioned that? Like just disconnect now. Okay, so I asked you those things so the court is clear. You actually gave various statements at different times about what happened that night. Would you agree? You gave different
That a
statements
yes or
about,
no?
you gave different statements about what happened that night. I'm talking about you filed for a personal protection order.
Yes.
You wrote an affidavit.
Yes.
You said you gave an account of what happened that night in these different
Yes.
documents. Now, you would agree that in your affidavit,
Objection, Your Honor. This affidavit is hearsay.
I'm impeaching.
Not a court statement. It was
He's
something
just
that
being, he's impeaching her. He just said she's made a different statement in the affidavit. I'm gonna give him some leeway. It's relevant.
Thank you, Your Honor. So in this affidavit, was this for Child Protective Services? Why did you prepare this? Yes?
Yes.
This is under oath? That's why it's an affidavit, right?
It was notarized.
Notarized.
That one's not, but the one that I notarized with Cassius's mom.
Does Miss Louie have a copy?
Yes, Mr. Louis provided me with this.
Yes, this was provided to me today and I kept it to defense.
All right, go ahead.
Okay, so in this affidavit, you claim that my client was hitting and beating on a car trying to attack you, correct?
His mom's car?
Yes.
Yeah.
You also allege that he hits you in the back, correct? And you allege in this affidavit that my client body slammed you.
There's a part that I don't remember. His son Cassius witnessed this part in the boys' room where he body slammed me onto the toddler bed.
Onto the toddler bed?
Onto a toddler bed, yes.
So this is upstairs?
Yes,
But until now, everything that happened was downstairs.
yes.
So you don't remember it, but you wrote it in a signed, sworn affidavit.
Well, I had told the person that helped me write it that I didn't remember that part.
But you signed it, and it contains a statement in here that my client body slammed you into Braden's bed.
Yes,
You also prepared a statement in an application for a personal protection order, right?
Is that a yes?
yes.
Then make it
I'm sorry.
and look the exact same when it's typed up.
I'm sorry.
That's why I keep asking you that. I know it's normal speech,
Yeah,
but the court recorder can't type that up and make it make sense.
okay,
So we're clear time-wise. You signed this, the affidavit I referred to for CPS on
Yes.
September 24th, 2025.
yes,
You also made some allegations in a application for personal protection order on the same day, right?
around the same time, yeah.
If it's dated September 24th, that sounds right. Would you agree?
Yeah,
All right. In the personal protection order, you actually make an allegation that my client choked you.
he has choked me.
He did choke you.
Not that night.
Not that night.
Objection, Your Honor. I'm going to object to this. He's not clear of which incident in PPO she talked about.
I mean, does she date it? Does she indicate that it occurred that night?
I'm going to object to that PPO just because it could involve other incidents.
Well, I mean, that's what I'm trying to clarify. For that person or for that purpose, your objection's sustained. But I mean, if there's a way to clarify, I don't have it. He's
Sure.
just using it for impeachment purposes.
Yes.
So I don't know one way or another, he can try and clarify that.
Yes, I can clarify. I'm referring opposing counsel to what I'll refer to as defendant's exhibit C. I think I have
Proposed.
video as B.
Yeah, proposed exhibit C.
Proposed exhibit C, the bottom of page 1, which is the statement of facts in the personal protection order. May I approach?
Yeah, I mean, you can impeach her with it. You can read it to her and see if she said it or not, or.
That's what I was my.
Yeah.
As long as it's from this incident date.
Ma'am, I'm showing you a page from the personal protection order.
Okay.
Is that accurate? Is that a page from the personal protection order?
Yes,
And is it true that there's a summation of your allegations from September 20th? Is that correct?
yeah,
You would agree that at the very bottom, you say that my client slammed you to the ground, choking and punching me in my face.
yes,
I read that accurately?
yes.
Can you
I'm gonna
turn
I'm
that
sorry.
phone off?
Yes. Your testimony about your injuries was that you received all these bruises from that night,
Yes,
right? And you also took some pictures of those bruises.
yes,
So the police never took pictures of those bruises?
no,
You provided some pictures to, was it the police officers in this case?
the detective,
Now, those photos are not time-stamped or dated.
no,
You also mentioned, I know we're jumping around, but I'm trying to keep everything straight. I apologize. You said that my client grabbed you and he caused some bruises by grabbing you, correct?
yeah,
Again, something you didn't mention to the police in that statement that we saw, right?
mhm,
Is that a yes?
Yes, that you
Yes.
didn't mention it? All right, so didn't you help my client take his boots off after he burned his boots?
no,
You didn't?
I don't think so.
So you can't say for sure?
No.
Now, ma'am, since you said you had some bruising, is it true that you underwent surgery shortly before this incident?
I had surgery
Ma'am, in the front row. You, in the black.
Apologies, you were saying?
In January, I had gallbladder surgery.
Right. And when you had gallbladder surgery, do you have some wounds from that
Objection,
surgery?
Your Honor. I think anything past that is irrelevant. If it was in January, this happened in September. I gave him the opportunity to get the timing of it, but anything that happened in January is not relevant to what happened at this time.
Where are you going with this?
She's claiming that she's had some bruising. I'm in possession of some photos. I know they're not admitted into evidence, but part of what we're trying to get at is, was she actually bruised because of my client allegedly doing these things?
I just want to point out that the only count I'm hearing evidence on really that's relevant today is count 1. I mean, the domestic violence aggravated is a misdemeanor offense. So it's going for whichever way. I mean, I've allowed you to continue because I thought that you were really doing this to attack her credibility.
I am, Your Honor.
And I presume so, but I'm going to grant the prosecutor's objection on that, and it's sustained. So.
Okay. If I could have a moment to consult with my client. Thank you. I have no further questions. Thank you.
Any brief redirect?
Very brief. So after you said he lit his car on fire, did you say he ran inside then?
Yes.
Did you follow him in?
I was right behind him because I had asked my stepson if he was okay. I asked Cassius if he was okay, and then I went inside.
And then did you observe him do anything inside in regards to the fire that was on his leg?
No.
Did he run inside with his leg on fire?
His boots were on fire.
Was it both boots?
I'm unsure.
And did you observe him attempt to what's the word? Put it out at all?
Yes.
How did he do that, if you remember?
I don't know how he put it out. I think just smacking it or hitting it.
Was anything in the house burned?
No.
And then in regards to your foot, did you say that he also hit the floor before hitting your foot?
Yes.
But did he throw the pan at your foot?
Yes.
And can you describe your injuries to your foot again?
I had black and blue bruising on the side of my foot, like where your baby toe's at.
And how did that impact you following this incident? What was the effect this injury had following?
Miss Louie, it's that, I mean, I respect what you're trying to do, both of you on this, but that is a misdemeanor case that I'm not here to hear evidence on that. I allowed it because I think defense counsel was saying it goes towards her credibility. It certainly appeared to be the case, but I'm not making a decision on the misdemeanor case. All I care about is the prep to burn real property.
I understand. And that home, that's your home?
I am first on the lease. He's a co-signer on the lease.
You both live there?
Yes.
And when he had lit his leg on fire, what were you feeling at that time?
Scared.
I have no further questions, Your Honor.
All right.
No recross. Thank you.
Thank you.
This witness may be excused.
All right. Yeah, ma'am, you're excused. Are you resting?
Yes, Your Honor.
All right, people rest. Any witnesses?
No, the defense rests.
All right. I'm going to cut to the chase here. You can make arguments if one of you want to preserve a record afterwards, and that's fine. The charge is prep to burn real property. Before I came here, I was the lead of the arson unit. And generally a prep to burn means you're pouring gasoline around the house or around a structure with the specific intent to light the structure on fire. I heard testimony today that a amount of lighter fluid was poured on the grass area by where the complaining witness was sitting. I saw the picture. It's a very small area. And that the defendant, according to the witness's testimony, then poured some lighter fluid on his boots, and then his boots went on fire, and then he ran in the house and promptly tried to put the fire on the boots out and then took the boots off. I mean, there is no evidence at all of the specific intent to burn a structure. There's just not. There may be specific intent to do something stupid if you believe the complaining witness, but there's certainly not enough evidence by a probable cause standard to find a preparation to burn real property. There's just not. And that charge is dismissed. There's not probable cause. There's a specific element that requires specific intent, and the witness just testified on redirect that she saw him run in the house. She came in shortly behind him. Nothing in the house was burned. He was waving at his feet to get the fire off, and then he took the boots off. So that's dismissed. Count 2's dismissed because there's no officer to testify to that. And that leaves us with the misdemeanor domestic violence, which would presumably be in front of me. So he's not bound over to the circuit court for future proceedings because both felony counts have been dismissed.
Your Honor, with all due respect, I did notify the court that I wanted to add a count, and if the court can just review this, it would be under MCL 750.200I1A. This word, the possession or use of a harmful device, being a chemical substance with the intent to frighten, terrorize, intimidate, threaten, harass, or injure, or kill a person. Again, he put this in front of her. It was at the home.
Here's the thing, Ms. Alui, about why I'm not adding that. And I'll let you make your record, but I'm going to be clear. Your witness is not credible. You have one witness that says this happened. The police officer, I can assume there's a reason they weren't called today. The officer on the video is clearly questioning her credibility at the scene. He just looks like he just woke up from a nap. She says he's punching her multiple times in the face. The officer says, I don't see any marks on you whatsoever. I mean, I, as a district court judge, have the duty not only to determine if there's some evidence of each element to a standard of probable cause, I also have the duty of making a determination on witness credibility and what I, as a finder of fact at this level, see as credible or uncredible. And I did not, defense counsel did a great job. She gave 4 different statements. She gave a statement at scene that's on body cam. She testified here. She had a PPO and she had a CPS statement. And each one of them had different types of assaults that occurred to her. I mean, she's just not a credible witness. And maybe it was because they were drinking. I don't know. But I just don't see the evidence, and I'm sometimes I think I'm doing the prosecutor's office a favor, because if I bind over on a charge with such a small amount of evidence, you have to prove that beyond a reasonable doubt once you get up to the circuit court. Someone, not you, another attorney, has the obligation of proving to a jury beyond a reasonable doubt that that crime was committed. And if I'm looking at it and I can't make a determination based on what I heard here today, that you can meet a probable cause standard, the likelihood of a conviction on a charge like that is essentially 0%. And I'm not going to, entertain it because I don't think your witness is credible. She told 4 different stories to 4 different people. And that's my ruling. So count 1 and count 2 are dismissed. And count 3 is a misdemeanor offense, so that will continue on. Now you want to talk about anything else, defense counsel?
I'm slightly unaccustomed to this, Your Honor, in terms of what happens now. But since a misdemeanor is left, I don't know.
It'll stay in district court.
Nice.
And I mean, you'll have to talk to your office. My experience is that NDS, if something like this happens, my experience is they generally keep the case.
I'm fine to keep this case.
Any other motions?
I would.
Come on, you could do it. You could do it.
I mean, I would move to dismiss or.
No, how about bond? Let's talk about bond.
Sure. Yeah.
I've got an individual in custody because there is an arson charge. He had a $2,500 10% with GPS tether bond. I've now dismissed 2 felonies. He's left with a misdemeanor that, in my opinion, is going to be, I mean, I don't know what other evidence is coming in, but that was not good.
Okay.
So are you making any requests as to bond?
Requesting a personal bond given what Your Honor just ruled. My client's been in jail for a number of weeks, months, and he'd like to get out and obtain his freedom so he can go back to his job. And I'm sure he'll have no incidents with this kill-off.
No, because I'm going to tell him right now, Mr. Pollington, you had a good day in court. Now I'm going to tell you how you screw it up. You have any contact with her whatsoever. And I'm going to tell you, if you do, I'm going to find out about it eventually. If you call her, write her, text her, have your mom call her, write her, text her, go on Snapchat, Instagram, WhatsApp, Facebook, Twitter, TikTok, I don't care. If I find out you contact her at all, I'll put you back in. But after what I just saw today, I'm not going to hold you in custody on this case. But listen to me. If you violate my no contact order, I'll lock you up.
Yes, ma'am.
I'm amending the bond. It is now a $2,500 personal bond. And I know there's a minor child the parties have in common. You go to friend of the court to figure it out. I'm telling you, you can't have any contact with her. And I don't know if there's a third. I'm assuming she has Daisy.
Yes, that's all we have together.
Okay. And if you need to contact her about parenting time, I'm going to tell you how you do it. You go to friend of the court and you get yourself a parenting time order. If you get your mom to call her and I find out about it, jail. You're going to have to do it that way because any contact is going to result in more charges for you based on what I saw today. Okay? $2,500 personal bond, no contact with complaining witness, direct or indirect. The only person who could potentially contact her on your behalf is your attorney. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. So I don't know where you're going when you're getting out, but you or your attorney have until tomorrow. You have 24 hours to make sure I know where to send your mail.
Yes.
No contact, direct or indirect. If you need child contact, you go through friend of the court and you follow their order.
Yes,
Your
ma'am.
Honor, I apologize for interrupting. Is there a GPS tether? Because if not, people would request one.
No, I'm not giving them a GPS tether. And if you want to make a record of anything, any objections you have, go ahead right now and make it.
Well, I would object to no GPS tether. There's going to be a personal bond, obviously, because of the severity of the circumstances and the fear of complainant.
No. Okay, you've made your record, it's noted. You cannot possess firearms or other dangerous weapons. You can't consume alcohol or illegal drugs. You may be subject to